Good afternoon, everyone. Thank you for joining today's online talk, which will be starting shortly at 3 p.m. For those who are here early, thank you for waiting patiently. While waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled Protecting Shareholder Rights with Corporate Litigation. My name is Tarani Kunasekaran, and I'm an associate with Ma Wing Kwai and Associates, and I will be a moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Ma Wing Kwai and Associates is a mid-sized law firm that was founded in 1985 by Dato' Ma Wing Kwai. Our able team today comprises of 37 lawyers and a support team of 28. Dato' Ma is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment and industrial relations team, and a department focused on serving the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with the COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsels. Before I continue, please be reminded that this talk does not constitute as legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Details will be given at the end of this talk. We have two speakers today, Sebastian Liu and Aaron Liu. Sebastian is a senior associate with MWKA. His practice areas include corporate litigation and corporate law advisory. He graduated with a Bachelor's of Laws from Cardiff University and obtained his Master's in International Finance Law from King's College London. Sebastian was called to the English Bar in 2015 and was called to the Malaysian Bar in 2018. Aaron is an associate with Ma Wing Kwai and Associates, and his practice areas include corporate and company law advisory, construction, corporate litigation, trust, and probate. He graduated with a Bachelor of Laws from the University of Manchester. Aaron was then called to the English Bar in 2020 and was called to the Malaysian Bar in 2021. Without delaying, I'll invite Sebastian to speak first. Sebastian will be speaking on understanding and protecting shareholders' right, while Aaron will be speaking second, and he will be speaking on navigating minority oppression and derivative actions, and on strategies to safeguard shareholder interests in companies. We will then conclude with a Q&A session. So if you have any questions, please do not forget to type it up in the Q&A chat box. So without further ado, I will pass it on to Sebastian to begin our session for today.
Thank you, Tarani, for the introduction. My name is Sebastian Liu, and I will be the first speaker for today's session. I will begin today's session by briefly speaking on the dynamics between a company, its shares, and shareholders. I will then proceed to speak on shareholder rights and mechanisms shareholders have in protecting such rights. My colleague Aaron will then speak on the potential remedies or avenues available to a shareholder in the event such rights are being infringed upon. So I'll begin today's session by explaining what is a company is a legal entity formed by individuals or groups to engage in business or other activities operating under the framework of applicable laws. Key characteristics include a separate legal entity. This basically means that a company is regarded in law to be a separate legal person distinct from its shareholders. It owns its own assets and liabilities, and shareholders are not directly responsible for the company's debts or obligations. Incorporated under law. This means that a company is established through incorporation under applicable legislation, such as the Companies Act 2016 in Malaysia, granting it its legal status. Limited liability. This means that shareholders of a company typically have limited liability, meaning their financial responsibility is restricted to their share capital or investment in the company. We will now move on to a company shares and ownership. In Malaysia, a company may issue different types of classes of shares. The two common types of shares are ordinary, which typically forms the bulk of a company's capital, and preference shares. Subject to the different class of shares, there are different rights attached to them. For example, fixed dividends is a typical feature for preference shares and voting rights in ordinary shares. So under the Companies Act, Section 2, shares means the issued share capital of a corporation. Shares, sometimes also referred to as equities or stocks, are instruments denoting some form of ownership of the company issuing them. Continuing on the topic of shares and ownership, a shareholder, sometimes also referred to as a member, can be either an individual or a non-human legal entity like a company, for example. A shareholder can be a person or a legal entity whose name is entered in the register of members as the holder for the time being, or one or more shares in the company. A shareholder is often still considered an owner or part owner of the company, where the owner's share is represented by the portion of the owner's capital injected into a company. However, in the case of limited liability in company law, shareholders do not own any of the company's assets directly and are neither directly liable for the company's debts. In general, their exposures are confined to the extent of their investments and are insulated from corporate debts. The company itself is liable for its debts, save and except for limited circumstances where the corporate veil can be lifted. But what is important to note here is that shareholders are typically not directly liable for a company's debts. Next, we will discuss shareholders' rights. As mentioned in my previous slide, the liability of the company is limited and ring-fenced to the company itself and generally does not extend to the shareholders and the directors. The shares only give their holders, for the time being, some typical rights, normally those to dividends, voting in shareholders' meetings, surpluses to liquidation, and corporate information during annual general meetings. Shareholders do not have a direct say in the management of the company. This is left exclusively to the board of directors of the company. At most, the shareholders' involvement in the management of the company is the right to vote at general meetings, to reconstitute the board, or to appoint or to remove directors. In extension to the previous slide, I will speak on shareholders' rights, specifically dividends. The first right of a shareholder that I will be discussing is the right to dividends. It is important to note that shareholders do not have an inherent right to demand dividends. Where dividends are declared by a company, only persons who are shareholders are entitled to them. Therefore, dividends are regarded as a right exclusive to shareholders of the issuing company, but it is not a guarantee. A shareholder's right to dividends is subject to the company's profits, policies, and board direction. The primary prerequisite to declaring dividends are based on the profits available. So under the Companies Act 2016, it provides that dividends should only be paid out of the company's profits, and declaring dividends when the company has insufficient profits can result in legal consequences for the directors. And so this brings us to the next point, board approval. The board typically has discretion in recommending dividends based on the company's financial health and future needs. So before paying dividends, the directors must ensure that the company can continue meeting its debts and obligation as they fall due after the dividend distribution. This is known as the solvency test, which typically requires that the company is able to pay all debts when they fall due 12 months after dividends are paid out. Once the above criteria are met, the board may, at their discretion, declare dividends to shareholders in proportion to their shareholding. The next typical shareholders' rights that I will be discussing in the shareholders' voting rights. This right depends on many factors. For one, whether the shareholder holds an ordinary or a preference share. If dealing with ordinary shares, such shares typically carry voting rights, allowing shareholders to vote on resolutions during general meetings. However, with preference shares, such shares generally do not carry voting rights. Voting rights, if any, may be granted under specific circumstances, such as non-payment of dividends, which are typical features of preference shares. The key voting rights of shareholders holding ordinary shares are to appoint or remove directors, which enable shareholders to vote and to elect or remove members of the board, to make changes to the constitution, which enable shareholders to pass resolutions to amend the company's constitutions if it is adopted, to enable shareholders to approve any major transaction of the company, such as the sale of substantial assets, to approve or reject share issuance, therefore have a direct say on the decisions about issuing new shares or rights offering, and to initiate voluntary liquidation. This is where the majority, approximately 75% of the shareholders or members, have decided for whatever reason that they desire to close shop. However, this can only be done when the company is solvent. As the list of shareholders' rights are plenty, I will focus on several other key rights that shareholders possess. These are the right to surpluses, which means that upon liquidation, after the company's secured and unsecured creditors are paid, the shareholders are entitled to any surplus assets after the debts and liabilities are settled. The next is the right to call general meetings. This statutory right is afforded to shareholders holding at least 10% of voting rights. Such shareholders can either requisition or convene an extraordinary general meeting of a company under the Companies Act 2016. Next, we have the right to receive notices and documents, where shareholders are entitled to receive notices of meetings, agendas, and relevant documents such as financial statements, say, prior to the general meetings. Next, we have oppression remedy, where minority shareholder can seek legal remedies if their rights are prejudiced or if the majority's actions are oppressive or unfairly discriminatory. And lastly, the right to winding up, where unlike a member's voluntary winding up, as I have discussed earlier, shareholders can petition for the company to be wound up by the courts if it is just and equitable to do, such as where there is substratum failure or deadlock or breakdown in relationship between the shareholders. My co-speaker, Aaron, will speak further on this later. Now that you have an understanding of shareholders' rights, we will discuss protecting shareholders' rights. Protecting shareholders' rights involve ensuring that shareholders can exercise their rights effectively and are shielded from unfair treatment or oppression. There are several ways to protect shareholders' rights. I have listed 3 points in my slide. The first is through a company constitution or articles of association. Another method is to draft comprehensive shareholder agreements that outlines each shareholder's rights, responsibilities, and obligations, especially regarding voting rights, dividends, and sale of shares, and dispute resolution. Such agreement can also specify procedures for protecting minority shareholders. And lastly, incorporating preemption rights into these documents. I will address each of the above points in the next slide. The first way to protect shareholders' rights is through the company constitution or articles of association. Before the enactment of the Companies Act 2016 in Malaysia, the Articles of Association served as the primary document governing a company's internal affairs and provided significant protections to shareholders. Together with the Memorandum of Association, these documents outline the rights, duties, and obligations of shareholders, directors, and other stakeholders. Today, adopting a constitution is optional. Under the Companies Act 2016 in Malaysia, a company can now choose to adopt a constitution to govern its internal management and relationships among stakeholders. While the Companies Act 2016 provides default rules where it applies if the company chooses not to adopt, a constitution allows flexibility to tailor specific rights and obligations, provided these do not contravene the Act. With a constitution in place, a company can modify or refine the default rules as provided under the Companies Act 2016 to better suit their needs, as long as they comply with the mandatory provisions which establish minimum standards for corporate governance and shareholder protection. So the benefit of adopting a company constitution and tailoring rights. I have again listed 3 points. The first is it provides flexibility where it may align governance structures with the company's specific needs. It can be used for conflict prevention, where predefined mechanisms may be in place to manage disputes, reducing ambiguity, and it can provide minority protection mechanisms, which include safeguards like veto rights, cumulative voting, or tag-along rights, which basically means co-sale rights to allow minority shareholder the opportunity to sell their shares on equal terms as the majority shareholder in the event of a sale. The second way to protect shareholders' rights is through a shareholders' agreement. So a shareholders' agreement is a legally binding contract between the shareholders of a company outlining their rights, obligations, and responsibilities in relation to their shares. So unlike the Constitution, which governs the company as a whole, a shareholders' agreement focuses on the relationship between the shareholders themselves and provides a framework for resolving disputes and making decisions. As discussed, the shareholders can safeguard their interests by including specific tailored clauses in their agreements, so long as they do not contravene the provisions contained in the Companies Act 2016. So in the interest of time, I will highlight 3 key protective mechanisms typically found in shareholders' agreement. The first is quorum provisions. Such clauses may require the presence of individual shareholders or representatives from specific classes of shareholders to form a quorum at a company meeting. In terms of this being a protective mechanism, requiring representation for specific classes of shares or key shareholders ensure that decisions affecting their rights or interests are properly considered. Secondly, voting rights. Shareholders' agreement can include provisions that give minority shareholders enhanced voting rights in certain decisions, ensuring their interests are protected even if they do not hold a majority of shares. And lastly, tag-along or drag-along rights provisions. As mentioned earlier, minority shareholders can protect themselves in the event of a majority shareholder deciding to sell their stake by ensuring that they have the right to tag along and sell their shares on the same terms. So similarly for drag-along rights, in the case of a sale of the company, drag-along rights can force minority shareholders to sell on the same terms as the majority, ensuring they can participate in a sale. The adoption of such provisions help protect shareholders from unfair or unilateral actions, preventing deadlocks, and to ensure smooth governance of the company, as well as providing legal certainty and safeguards the rights of all shareholders, particularly minority ones. In matters of company control and decision-making, these mechanisms should be considered at the outset. And lastly, for my part, we will be discussing preemptive rights. So preemptive rights are an important mechanism designed to protect shareholders from dilution of their ownership and control in a company. These rights give existing shareholders the first opportunity to purchase newly issued shares before they are offered to external parties. Preemptive rights also grants existing shareholders the right to purchase shares being sold by another shareholder before they are sold to a third party, preventing dilution of their ownership in a company. In our jurisdiction, preemptive rights are not automatically implied by law and must be explicitly provided in the company's constitution or a shareholders agreement. In short, this right is not automatically granted and has to be expressly spelled out in order to have effect. As a protective mechanism, preemptive rights are a vital tool for safeguarding shareholders' interests, ensuring proportional ownership, and maintaining a balance of power within the company. However, the application requires clear provisions in the company constitution or a shareholders agreement to be enforceable and effective. Therefore, in the absence of any such expressions, there are no implied preemptive rights by law. So that concludes my part. Thank you for listening. I will now pass the screen over to my brother Aaron, who will highlight the remedies that are available to aggrieved shareholders in the event things turn sour. Thank you.
Thank you, Sebastian. Hi, everyone. For my part of the talk, I will be talking about how to navigate around net minority oppression and derivative action in the position as a minority shareholder in a company. So what is a minority shareholder? It essentially means a shareholder with a non-controlling stake of less than 50% of a company's voting share, which means that you're not controlling the company, you do not have the majority shares of currently under your control in the company. So a minority shareholder does not have sufficient voting power in the company to exert control over a company or to have any significant influence over the direction of the company, essentially meaning that a minority shareholder can only follow what the majority shareholders are doing or having any plans for devising any plans for the company's future planning. This concept is similar to a sovereign democracy where we vote in general election, and then of course whoever takes more votes will become the government. Essentially, corporate democracy is also one of the fundamental principles of a company law and also good corporate governance, which we usually call the majority rule. Now, as a general principle, like what I have mentioned just now, minority shareholders must continue to accept the principle of the majority rule. This was held in the Privy Council's decision in Re Kong Tai Sawmill, Miris and Yuan Berhad, where Lord Wilberforce held that those who take interest in companies limited by shares have to accept the majority rule. And also, it is only when majority rule passes over into rule oppressive of the minority or in disregard of their interest that the section can be invoked. This essentially means that no matter what the majority shareholders of the company is doing, the minority shareholder can only follow what they are planning to do. So when it comes to minority oppression, it would essentially means that something must have been done by the shareholders, majority shareholders, which infringe into the rights and benefits or interests of the minority shareholders in the company. This can be a very long list of whatever rights or interests a minority has felt like it has been infringed upon. So some decided court cases has expanded the scope on what may be deemed oppressive to the minority members, including the misappropriation of assets belonging to a company. This means that there are some assets, for example, like shop lots, houses, or anything that's currently under the company were transferred or sold without any knowledge of the minority shareholder. So there are certain types of information which were concealed away from the minority shareholders, for example, recent dealings, recent contract signing, or whatever that may hold a substantial value or may have an impact towards a company's corporate governance or even a company's future planning. The diversion of profits to the majority members at the expense of paying minority dividends. So this essentially means that the majority members will try to divert profits earned by the company to themselves rather than paying any dividends to the minority shareholders, or rather pay at a lesser value to the minority than what they were supposed to be based on the percentage of the shares. Next would be the prejudicial mismanagement, which means that majority shareholders are managing the company in a way or extent that it's very prejudicial towards the minority's interest. So for example, where you can see that all the decisions making were in favor of the majority shareholders and whatever they are doing in relation to the company, and the minorities' voices were not being heard or they don't get any benefits from any kind of these managements. This can happen quite common in terms of a family business where a certain family member is controlling majority of the company, but the minority one felt left out. And of course, like the failure to pay adequate dividends, this always happens. This is quite a common scenario to happen in terms of a minority oppression where the minority didn't get enough dividends exclusion of certain class of members, like what I've said, family business always happen these kind of things where certain class of members were being excluded from the management, especially when they're minority shareholders, which in general terms, they would be regarded by the majority as to they don't have enough say in the decision making. Failure to hold AGMs, which essentially means that there's no annual general meeting being held by the company, being held by the shareholders to go through what has happened in the company throughout the years, and no information whatsoever available to the minority shareholders as to what is going on in the company. And lastly, the dilution of shares. This is of course like what my colleague Sebastian has mentioned. The dilution of shares means issuance of new shares, which would benefit the majority shareholders more and further dilute the shares owned by the minority shareholders in the company, which further lessen their power, their already minor power in the company. So when minority oppression comes about, where the majority rule has been abused by the majority shareholders, the current law does provide these kind of mechanisms to protect the minority shareholders from any such unfair treatments. This is particularly held in Section 346. So now minority oppression is also something similar to an unfair prejudicial petition in the UK, but for the purpose of local jurisdiction, what we will only be confining into Section 346 of the Companies Act. Section 346 reads that any member of a company may apply to the court for an order on the ground that the affairs of the company are being conducted in a manner oppressive to one or more of the members, including himself, or in disregard of his or their interests. So this essentially means that any shareholders, if in the due course of running a company, realized or found out that the directors and majority shareholders were running the company in an oppressive manner, which is not beneficial to the minority shareholders or disregarding their interests, then the minority shareholders can, under Section 346 of the Companies Act, apply to the court for an order for minority oppression. Now, Section 346 sub B says that some act of the company has been done or is threatened, or that resolutions has been passed on which is proposed which unfairly discriminates against or otherwise prejudicial to one or more of the members of the company. This essentially means some of the company's decision that are really unfairly discriminates. What is unfairly discriminates? Of course, this would have to be applied in a very commercial sense, and essentially the shareholders would have to feel that they were being discriminated even as a shareholder, although as a shareholder, but owing to the fact that they are the minority in the company, they were being discriminated upon. So what happens when there is a wrongdoing committed against a company rather than against the shareholder personally? This is another recourse that we call a derivative action, where instances where directors committed wrongdoings like breaches of any fiduciary duties to the company, the shareholders can have a recourse through a derivative action. Derivative action is a recourse available under Section 347, subsection 1 of the Companies Act, where a complainant may, with the leave of the court, initiate, intervene in, or defend a proceeding on behalf of the company. So, for example, let's just say that where a shareholders had majority control of the company and is using the company for his self-benefits, which causes the company to suffer a loss, which in turn causing the minority shareholders to be affected, including their rights, interests being inflicted upon. This is where a shareholder can initiate a proceeding on behalf of the company to make things right. The derivative action, the doctrine of derivative action comes from a very famous English precedent, where the case of Force against Harbottle, where it was held that the company is a separate legal entity and can be sued in its own rights. If any loss is suffered by the company by the negligent or fraudulent actions of its members or outsiders, then an action can be brought in respect of such losses, either by the company itself or by way of the derivative action. So we have already discussed about what's minority oppression and what's derivative action. What are the strategies that really safeguarding the shareholders' interest in companies? And aggrieved shareholders in such a situation will have to litigate under his or her personal capacity as the shareholder of the company. And like I have said just now, the legal test for oppression is whether there is commercial unfairness in the treatment of a shareholder and is assessed on a case-to-case basis. So this really, although what a minority shareholder may feel oppressed may not feel the same in other case. So this really it depends on case to case, and also from a company to another company. So what to do next? Of course, like what my colleague Sebastian has mentioned and also explained just now, shareholders agreement, protecting shareholders' rights, set out a very complex and very detailed one. This is an essential preemptive action or step to be taken by all shareholders to have a shareholder agreement in place to set out all clearly and precisely what are the terms, rights, and interests of each shareholders in the company in the shareholders agreement. And this may also include some other rights which may be essential, for example, drag along and tag along rights, where minority shareholders may be able to tag along the majority shareholders to sell their shares in the event the majority is managed to push through an acquisition to sell off the company. Drag along rights means that majority shareholders would be dragging along a minority shareholder to sell the shares in the company together, notwithstanding that whether they are majority or minority, as long as these terms are included in the shareholders agreement. There are some reserved matters, for example, like what reserved matters that shareholders can do and at board level and members level, and also what are the dispute resolution terms and clauses that the shareholders can go through when there are some disputes between the shareholders in relation to the management of the company. Now, like I have mentioned just now, there are two ways for protecting shareholders' interests, one being the minority oppression and the other one being a derivative of action. But more often than not, what action that a minority shareholder should really consider? In the case of Lau Ching Teck and others against Low Yan Ni, this is a fairly recent case. As you can see, it's a 2024 case. The court held that an oppression claim premised on the circumstances set out in Section 346 is a personal claim made by the minority shareholder who suffers a distinct and personal loss, while derivative action is brought on behalf of the company by the shareholder in a representative capacity. So this case essentially means that for you to be able to find out which cause of action that you want to find, being you want to be relied upon being the oppressive or derivative action, it really has to go down into whether the actions or the decisions made by the company or the majority shareholders affect you as the minority shareholder in your personal capacity, or affect you, not only just affecting you as the minority shareholder, but also the company as a whole. Like what I have mentioned just now, losses of profit, losses of assets, all these kind of things, whether it's a loss towards a company rather than personal capacity, then of course that would be a derivative action. Section 346, subsection 2 of the Companies Act offers certain remedies for the oppressed minority by the court, which the court would order a share buyback by the majority shareholder to buy back all the shares of the minority shareholders, or will provide any injunctive or directive reliefs to further direct or order the management of the company. And lastly, if the trust or the relationship has completely broken down, then the court may also order to wind up the company on just and equitable. On derivative action, it's because the action is done through a company, as what I have mentioned just now. It's an action that has to be started by a company. A shareholders more often than not would be able to have the power to commence derivative action on behalf of the company to seek remedy against those wrongdoers inside the company or even outsiders. More often than not, this kind of derivative action will be filed when the majority is controlling the company as the director of the company, and the director and the board has been making decisions which are not beneficial and at a very disadvantaged position, which causes the company to suffer a loss. Shareholders may apply for leave to commence the derivative action into the court, and the court would determine based on the circumstances and also the factual situation whether to grant a leave or not to initiate the derivative action. Once the leave has been granted, the action can be taken in the name of the company against the wrongdoers. This essentially means that the minority shareholders will represent the company to go against the wrongdoers, be it the directors of the company or even whoever controlling the company. This, which is why a derivative action, whether a derivative action is the appropriate mechanism, really depends on whom the wrong is being directed to, and this is determined by case to case. And lastly, if let's say minority oppression or even derivative action fail, what minority shareholders can do is to attempt to wind up the company by way of a just and equitable winding up. This just and equitable winding up can be filed on the petition can be filed on the basis that the trust between the shareholders have broken down, and it's irretrievable and unable to be repaired. So the aggrieved party may file a winding up petition in the High Court to wind up the company to resolve this kind of shareholders dispute once and for all. To file a wind up the company, calculate all the assets and whatever liabilities that's currently with the company, repay back all the debts and everything, and distribute all the remaining assets to the shareholders based on their share composition. This is held in Section 465, subsection 1H of the Companies Act, where the court may determine whether to just and equitable wind up the company. So that's all for my part for today, and I'll pass back the floor back to Tarani. Thank you.
Thank you, Sebastian and Aaron, for your insight on protecting shareholder rights with corporate litigation. We will now take questions from the participants from the Q&A chat box. Kindly note that we are unable to offer specific legal advice. This requires a formal engagement so that we may uphold lawyer-client privilege. As such, please ensure that your questions are structured in a general manner and in line with our topic today. So there are a few questions from the audience. The first question would be to Sebastian. Can directors on the board have equal voting rights, notwithstanding some may have less shares or none than other directors?
So at board level, directors generally have equal voting rights, regardless of whether they were nominated or appointed by a minority or a majority shareholder or a smaller or larger block of shareholders to represent basically they're appointed to represent a particular block of shares. So once appointed, directors are expected to act in the best interest of the company as a whole, rather than prioritizing the interests of shareholders who have appointed them. So to answer the question in short, directors have equal rights at board level, regardless of whether they represent a large or smaller faction of shareholders.
Okay, thank you, Sebastian. The second question would be, can a minority shareholder report a wrongdoing as a whistleblower? And will this incriminate the minority shareholder as he or she is a part of the company? So I'll repeat the question again. Can a minority shareholder report a wrongdoing as a whistleblower? And will this incriminate the minority shareholder as he or she is part of the company?
For this one, actually, it really depends on how big the company is or how involved the minority shareholder is. Of course, while you say whether it will incriminate the minority shareholder if he or she is a part of a company, it really depends on a case-to-case basis, where it will have to depend on how involved is this shareholder in the company. Is he a director having access to almost all financial information, financial records, or even like all managerial decisions, taking part in all these managerial decisions? At this juncture, whether you reporting a wrongdoing as a whistleblower will incriminate yourself or not, it really depends on how involved you are, and also whether anyone else will immediately find out that you have reported a wrongdoing, even though you reported anonymously.
Thank you for the answers, Aaron. So the next question is, can I use Section 346 against the directors in a REIT?
So we're not too familiar with the structure of REIT, so it depends on whether it's structured as a company. So in short, Section 346 primarily applies to shareholders of a company where the affairs are being conducted in a prejudicial or oppressive manner. So the objective is to bring unfair treatment to an end. Therefore, because oppression remedies include a buyout or a just and equitable wind up. So it depends primarily on what this REIT structure is. Is it structured as a company or is it something else? If it's a trust or anything, it may not be applicable.
Thank you, Sebastian, for the answer. I've got another question here. For derivative action, when applying for leave, we would sue the subject company as one of the defendants. If the wrongdoer enter appearance for the company, can we strike out the company's appearance?
If the wrongdoer enter appearance for the company, I think it would be unnecessary for you to go to strike out the company's appearance, because of course the wrongdoer is currently controlling the company. And even if they enter the appearance, what you can do is of course to tell the court that we have filed this suit on behalf of the company for the wrongdoings, and it is now at leaf stage. So whatever needs to be dealt with, of course, we have to deal with in the financial stage.
Thank you for the answers, Aaron. So that's all of our questions for today. But before we conclude, I have a few announcements to make. First, please join us again for our upcoming talk on Wednesday, 4th of December 2024. The topic would be medical negligence claims in Malaysia, a guide for foreign patients. Secondly, please fill in our feedback form and let us know what you think about our talk. The link to the form will be posted in the chat box. Thirdly, do follow and like our social media accounts. Fourthly, if you would like to speak with our lawyers, we offer a complimentary 30-minute consultation over the telephone or over video conference. Please fill in the form on our website. The link is also posted in the chat box. Thank you to our guests. Thank you for joining us today. We hope that you have found today's session informative and useful. Thank you, everybody, and see you at our next talk.